You know, I don't really know how you people do view the judicial system. Some people do say it is unfair. Once your party is in power, no say utimi ye de upebra emre obi anya wo hwe. My ladies and gentlemen, according to the Attorney General of the Republic, asem o ka che Ghana fo ni na say there be Kwabena Duffuor case na ye twemu no anase ye free court no. You people should relax because the way you people are putting things up there, especially the NPP. Asem ne ntesa or say abandon Duffuor case in just because of say ever since these 6 years the NPP our mode assembly call court no omunya evidence ba kumpo a chese Kwabena Duffuor oria aban sika. But remember I said the charges against Kwabena Duffuor no was said he has caused financial loss to the state, but rather onia nipa and also onia oman. So there is a difference between say obia cause financial loss to the state and then someone who has stolen from the public purse. Ladies and gentlemen, this is the words of the Attorney General. So obi wanu mo obetimi area oman sika omusa no the money is for themselves. And then for those who cause financial loss to the state, it can be intentional, but that doesn't mean say sika no ko omo hono dabi. No. So the main reason omo I withdraw case in is say now there has been an agreement between them, and then this time around Honorable Duffuor said he's going to pay huge amount of money to the Bank of Ghana and then to the state. Here is the BJ show. Yenti Asema, the Attorney General, Edituja,
made a proposal to settle the revised outstanding obligation of 3.3 billion Ghana cedis through a structured approach. The accused persons offered to pay 2 billion Ghana cedis in full and final settlement of the outstanding obligations through the following arrangements: 800 million worth of assets to be transferred directly to Unibank, which is in receivership, which will now make that available to the Bank of Ghana. And then their active cooperation and participation to assist the receiver to recover an additional 1.2 billion from the direct beneficiaries paid out on their instructions. Out of the above arrangements, the accused persons have provided landed properties valued at 824 million Ghana cedis to Unibank, that is, in receivership. Further, in other words, indirectly to the Bank of Ghana or the Republic of Ghana. Further, the accused persons will be responsible for any shortfall in the proceeds realized from the sale of the landed properties. A total of 0.5 billion has to date been recovered out of the 1.2 billion being pursued from the direct beneficiaries. Recovery of the remaining balance of 0.7 billion out of the 1.2 billion Ghana cedis and the realization of the landed properties provided are expected to be completed over a timeline of 18 months. Although the preference would have been for me and my team for the accused person to settle the proposed amount in cash, immediate settlement in cash was not, from my sense of what transpired at the negotiations, a realistic possibility or a realistic option. In assessing the proposal submitted by the lawyers for the accused persons, I took into account the following factors. The receiver of Unibank acknowledged that the fictitious amounts totaling 2.1 billion did not result from cash outflows, but related to accounting entries that overstated the asset base of the bank, which predated Unibank's placement in official administration. B, a claim for the placement of 0.3 billion with the SEC-regulated entity was filed by the receiver with the official liquidator in 2019, and its recovery is being pursued separately through the insolvency process. 3, both the criminal and civil cases have persisted over 6 years with no immediate resolution in sight. The complex nature of the legal proceedings has significantly delayed any meaningful recovery. Now, come to think of it, those who instituted the criminal proceedings did not foresee the possibility down the line of recovering assets and never engage in any asset recovery process. They did not trace, to find out what assets were in the hands of third parties including those who were in court. So while the criminal prosecution was intended to serve as a punitive and deterrent measure, it is through the civil process that actual recovery of funds is effectively pursued. The accused person's proposal fell within the receiver's mandate to maximize recoveries for Unibank in order to settle the bank's creditors, mainly Government of Ghana and some institutions. There is also a genuine risk that prolonged litigation could ultimately lead to lower net recovery, especially when accounting for legal costs, procedural delays, the time value of money, and the potential dissipation or concealment of assets. By contrast, the current arrangement secures the timely resolution or recovery of over 800 million Ghana cedis in assets and establishes a structured pathway for recovering an additional 1.2 billion Ghana cedis with the active cooperation of the accused persons. On the other hand, should the matter have continued in court, it would likely have faced prolonged delays, including multiple procedural applications, adjournments, and appeals. Even if judgment were eventually obtained in either the civil or criminal proceedings, enforcement and execution could take years, further deferring any meaningful recovery. It is clear from the foregoing that I took a pragmatic, holistic approach by engaging the receiver and the accused persons to broker a resolution that settles both the criminal and civil dimensions of the case. This strategy recognizes that while criminal proceedings are punitive, the real economic value to the state lies in a non-conviction-based asset recovery approach. The terms of the settlement are structured to ensure that the Attorney General, the Bank of Ghana, the Minister of Finance exercise oversight over the recovery of the negotiated amounts. Progress under the agreement will be subject to quarterly reviews to ensure that the accused persons fulfill their obligations as agreed. Ladies and gentlemen of the media and my fellow countrymen and women, it is important to correct certain misunderstandings or distortions, deliberate in some cases, that our team picked from the media space regarding this matter. Since my press release, it has been said that by setting a minimum threshold of 60% for the recovery of assets as a condition for filing a nolle prosequi or terminating the banking sector cases, I have cut a deal which permits persons who have stolen or looted public funds to walk away with 40% of the loot. At least that is the narrative, by some sections of, the Ghanaian populace, particularly from our opponents in the MPP who were responsible for all this mess. Indeed, one writer on Facebook compared my decision to the situation where someone has stolen 6 goods and is being told by the prosecutor to return 4 goods and keep the 2. But my fellow countrymen and women, now this may seem like a joke, but it's a very serious expression of the sense of justice of our community. And it is something that I have used, to, get people who have come to me for plea deals to get them to think about the community's sense of justice. So, it is not lost on me, and I wasn't surprised when I read this on Facebook. But the goat thief analogy, intriguing though it may be, is an oversimplification of the matter. This is why. First, Dr. Kwabena Duffuor and the other persons standing trial were not charged with stealing or looting of public funds. They were charged with causing financial loss to the state, fraudulent breach of trust, falsification of accounts, as I have pointed out earlier, dishonestly receiving, and money laundering. But the facts and the evidence supporting these charges never allege that those standing trial personally benefited from the banking transactions that gave rise to these charges. Now, it's important to make clear that when someone is charged with, for instance, causing financial loss to the state, all right, it does not imply from a criminal liability point of view that they took the resources that have been lost. In other words, what we seek to do when we charge someone with causing financial loss to the state is to prove that they either intentionally or recklessly or negligently caused the state to lose resources or to lose funds. All right. Now, those of you who are old enough to remember the Quality Grain case, which came, and went all the way to the Supreme Court, involving the former Deputy Minister of Finance, Victor Salome, and a number of NDC officials in the Rawlings regime. You'll remember that in that case, Justice Afre was at pains to point out that though the accused persons had been convicted of the offense of causing financial loss to the state, they had not been convicted of stealing. They had not been convicted of personally benefiting from, the actions that were the subject matter of the criminal charges. All right. We must also understand that though the charge of fraudulent breach of trust is closely related to the charge of stealing, the facts and the evidence didn't show, okay, that in this particular case, they fraudulently breached their trust because they stood to benefit. Okay, they entered into transactions with third parties, okay, which pointed to the fact that according to the case that was filed, they were trustees of depositors' funds. Now, which in itself is legally contestable, right? Because the banker-customer relationship is not one of trusteeship. It is one of contract. Now, that is legally, established in case law. There are case law precedents to the effect that that relationship is not one of trusteeship. So when someone deposits their money in a bank, all right, they are not keeping the money, they are not giving the money to the bank to be held in trust. Okay? So that if that were the case, then the beneficiary would be the one dictating how the monies, should be used. But banks are at liberty, because it's a contractual relation, a commercial relationship, at liberty to lend the monies, do, banking transactions with those funds.
So that's the Attorney General of the Republic of Ghana. At the accountability series, and Oma Ghana phone in who said, SMC are Munyan to Boise, and then the NPP, they are trying their best to say they will put a lot of falsehood out there. So I say, assemble on Ghana for Union to Boise, because the law is the law. And then all those who took the public money, and I say, Omutimi Viefri or mine, Honomono, Ubia Edis Nisika Beba. Ladies and gentlemen, here is the BJ show. Mr. Kaiso, subscribe. Your friends will be a link in my for the next thing is you do well to leave a comment. But fast forward, and my first time you and him say, if you are a student within the education system, and then if you want to vie for any position, Michelle Sebani said, would they say, course rep do well to call the BJ show. We are here to help you to tell the people about your manifesto, and then let them know, say, this is what you are having for them. So do well to call 05 999 111 05 999 111. We will come to wherever you are